business, the invoice. Is that, what are we?
Yeah,
Everyone counts.
it's the fourth quarter, which will be their final invoice.
Mm-hmm.
They do a CAVA implementation, online ballot marking system.
Are we specifically approving that, or is there a reason it's on the agenda?
Yeah,
We need to
like
approve
We
it?
always
Okay.
approve it, yes.
All right, we have an invoice for Everyone Counts Inc., which provides services, master service agreement for our overseas and military balloting system, right?
Yes.
That our invoice is in the amount of $74,300. Is there a motion to approve? Moved by Commissioner Cowan.
Second.
Seconded by Commissioner Hernandez. Further discussion? Hearing none, all those in favor? Aye. That'll be the order. Legal status report, Mr. Scanlon.
Mr. Chairman, Commissioners, as you know, the plaintiffs in the Barrow versus Lehman case filed notice of appeal.
Yes.
The Seventh Circuit U.S. Court of Appeals. That was filed on Friday. The plaintiff's brief was due on December 14th, and that brief will be due 35 days after that. So I'll certainly keep the commissioners apprised of any new issues with regard to that. Just go forward and defend it on the case.
Excellent performance by the legal department during the election also, Mr. Scanlon. Financial report, we have none. So we'll move to the public comment section. Anyone here carry anything for us today from you?
Well, I did.
How are things in the second ward?
I don't know about the whole second quarter. Well, actually, I'm in the fourth quarter.
Fourth
Yeah.
ward, I'm sorry, you're in the fourth ward now.
I did visit 2 precincts, and things really were, I thought, being well done. There was a family that came in and wasn't able to vote at that precinct, and they said this was the 3rd one they'd been to, and I wasn't able to get over and talk to them before they got on the elevator, so I don't know what happened to them.
Hopefully you found them.
Other than that, the spilled orange juice was a big problem.
Believe it or not, I heard about that. I got a phone call.
And actually, Prairie Shores put up notices saying, if you live in this building, your precinct is at so-and-so.
Oh, great, great.
So
Excellent.
I maybe had a little bit to do with that because I called up and asked if
Everything
they
pretty much.
send a bus over for people.
Well, good, thank you.
Yeah.
All right, anyone else? Sharon, Ms. Meroni.
Good morning. How are
Good
you
morning.
today?
Fine.
But I have a number of items I wanted to bring up. First of all, just quickly, Mr. Scanlon, I didn't, what was that one case that's pending right now? What's the item, what's that about?
The Navarro case I mentioned?
Did you call it Navarro? I couldn't hear that.
Navarro.
Navarro. Oh, it's a Navarro case?
Right.
Okay.
That was a case, there were vacancies in nomination after the primary election, and no one was nominated at the primary.
Correct.
The candidates, and they're all Republican offices. There were 3 state senate, 3 state rep. The candidates filed petitions. Objections were filed. After the objections, the candidates had fewer than the required number of signatures necessary to qualify for the ballot. They did not seek judicial review in the circuit court. They waited until September, middle of September, to file an action in federal court. And they claimed that the requirement that candidates who fill vacancies in nomination, where no one was nominated at the time, was unconstitutional. They challenged, there was an amendment, the 2010 amendment to the statute that instituted a requirement that they file petitions with the same number of signatures as they would have needed to get on the primary ballot. And they alleged that was unconstitutional. In the federal court, the district court, granted our motion to dismiss. The court found that there was nothing unconstitutional about the statute. And they also held that the plaintiffs essentially waited too long to file an action in federal court, and they slept on their rights. So that was the decision of the federal district court, I believe on October 15th, and that's being appealed now in the Seventh Circuit District.
Who's the appellant, who's the plaintiff's attorney, do you know?
David,
David Radowitz, by any chance?
David Radowitz.
Got it, okay, excellent. Thank you, I was interested in hearing about that.
Mhm.
Okay, so then I was also wanting to ask, when you did the mailing to alert the voters of the poll changes, did you get a bunch of them back that then you correlated those return mailings to reduce voter registration issues?
We do collect the return mail from any mail, whether it's, we also did for the first time a supplemental poll list mailing to those voters, which helped reduce, I think. But if we get any mail back under any process, we keep that and we record that, and that can lead to someone being marked inactive. However, Jim, correct me if I'm wrong, under federal law, we cannot use any mailing after 90 days before the election for the purpose of changing someone's voter status or making them inactive or otherwise challenging them at that election. We can use it after this election to modify their status.
And so do you keep a record of how many came back, or do you have some kind of report about that? I recognize that you can't do anything that 90-day period, but I'm curious how many came back and how you guys process that data internally.
Yes, we process, we scan in every one of those items, as a matter of fact, and that becomes part of the voter's record internally, so that if the voter were ever to come back to us and say, how did my status change, we're able to retrieve that information and provide that for the voter.
No, that's
Absolutely.
Good. That's good. Thank you. I guess you guys will be taking some names off the rolls anyways, now that 90-day period is, but you don't have another election for quite a while, do you?
Well, we don't know.
Except that special election
Yeah,
possibly.
we don't have the citywide election until March of 2014.